Good morning, Mr. Shriver.
Good morning, Josh. How are you doing today?
I'm doing well. How are you?
Yes, Thursday.
All right.
We can't hear you, Judge.
Can you hear us in the county jail? Can you hear us?
Here you go.
Okay, thank you. Ms. McLeod, can you hear us?
Yes.
All right. Mr. Shriver,
Thanks, Judge.
as to the constitutional rights, will you be waiving? Would you like me to read them?
Your Honor, we waive. We're happy to explain to Ms. McLoyd her rights.
Have you already spoken to her and explained them?
I have not, Your Honor, so if you'd like to read them for this,
Given the nature of the charge, Ms. McLeod, please listen carefully. These are your constitutional rights. It's my duty to advise you of these rights. These instructions are important. Listen carefully. Under the Constitution of the United States and the state of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. These are the right to know and understand the charge against you, the right to a speedy trial, the right to a trial by jury. You may waive or give up that right and have your case tried by a judge without a jury. At trial, the state of Ohio has the burden to prove your guilt by evidence beyond a reasonable doubt, the right to meet your accusers face to face and to cross-examine the witnesses for the prosecution, the right to summon or subpoena witnesses on your behalf. You do not have to testify against yourself. The right to counsel. If you are unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you are unable to pay this fee. At the end of your case, you may be ordered to pay the fee if the judge determines you are financially able. If you choose to hire your own attorney, you have a right to a reasonable continuance to hire one. You are not here for the trial of your case. You are here for the arraignment. An arraignment is your opportunity to be informed of the charges against you, for bond to be set, and for you to enter a plea. You do not have to make any statement about the charges against you, but any statement made by you may be used against you. As your name is called, you will be arraigned and your attorney will speak on your behalf. You will be asked and your attorney will respond if you've received a copy of your indictment and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to this indictment. If it has been less than 24 hours since you received a copy of your indictment, but you wish to be arraigned anyways, you may waive the 24-hour notice and we will complete your arraignment this morning. If your case is going forward this morning, we will proceed at this point in time. You will be asked how you plead. The defendant may plead not guilty by reason of insanity, guilty, or with the consent of the court, no contest. If you want to plead guilty and you do not have a lawyer, the court will assign counsel for you. Mr. Shriver from the County Public Defender's Office is here. Mr. Shriver, let's proceed. As far as the reading of the constitutional rights, are you satisfied?
yes, Judge. Your Honor, Ms. McLoyd's in receipt of this indictment. We would waive the 24-hour notice, waive any reading in court, waive any defects in service, and enter a not guilty plea. Your Honor, we'd ask for a reasonable bond at this time. Would ask for counsel to be appointed and for the opportunity to respond to the state's presentation.
Mr. McLeod, have you heard everything that your attorney has just stated?
Yes, sir.
You are in agreement with that?
Yes.
All right, we will proceed. The state of Ohio, do you wish to have any statements made at this time?
Yes, Judge, thank you. Kevin Filiatro here on behalf of the state of Ohio in this case. Your Honor, we ask that this defendant be held in this case without bond under Revised Code Section 37.222. And we are prepared to present those factors today. If the court is inclined to relay that motion to the trial judge, we would ask that a $5 million bond be set on this defendant in this matter, consistent with the bond commissioner's recommendations. I would note, under the factors, Judge, the evidence against this defendant is strong. This crime is captured on video. This defendant was arrested later the same evening into the early morning hours of the next day with a revolver on a person. and she did ultimately confess to shooting Officer Bartek with that particular revolver. I would note this defendant certainly presents a serious risk of harm to the community, and there are no conditions of release that can guarantee the safety of the community if this defendant is released. And I'll note in support of that, this defendant was placed on probation in Lorain County Juvenile Court on October 28th for a crime of robbery with the commission of a firearm with two other unnamed co-defendants in that case. She was on probation on that robbery when she committed other offenses, which you're going to arraign her on after this case, and then this offense on New Year's night. Officer Bartek was just walking to his car. She approached him, robbed him. He did not struggle with her. He gave up his keys. He pointed to where his car was in the lot, and he attempted to disarm her, after which she fired twice. So, Your Honor, with that being said, we feel that this defendant should be held without bond.
Thank you, Mr. Filiatro.
And I'm sorry, if I could just say one more thing.
Please.
I have spoken with our Officer Bartek's family, and they are in agreement with what I've just stated on the record. Thank you.
Has this matter been reviewed by the Capital Review Committee?
Not yet, Judge.
Is there a reservation notice on the indictment itself?
There is. The state has reserved the right to proceed with a superseding indictment seeking the death penalty in this case.
Mr. Schreiber?
Your Honor, would just state, as far as the state's request to hold Ms. McLoyd without bond, regardless of what the capital unit may do at a later date, at this point, she is not charged with a capital crime and I believe is entitled to bond. That said, Judge, everything in the state's recitation, of course, has not yet been proven. Ms. McLoyd, as a matter of law, is an innocent person. Asked the court to set a reasonable bond that she could conceivably make. I disagree with the state's assertion that no conditions of bond could guarantee the safety of the community. The court is aware, of course, that Ms. McLoyd can be placed on DPS or home arrest if she does make any sort of bond. Obviously, understanding the nature of the charges, we understand the court will set a high bond, but we are asking the court to set bond.
Mr. Filiatro, are you calling anyone to the witness podium or no?
No, the state will not call a witness at this time.
The court has reviewed all the factors in Criminal Rule 46, also reviewed the relevant case law, the recent case law from the Ohio Supreme Court regarding bail to be set. The court will set a bond and follow the bond commissioner's recommendation and set a $5 million bond, cash surety property. There will be no contact with the victim's family. The defendant will be placed on a 24-hour lockdown, on home detention, standard monitoring, GPS, should that bond be made. In case number 666571, the court will address that bond as well. In this matter, the court will assign attorneys Thomas E. Shaughnessy and Jay Schlackett. This will be going to the docket of Judge John O'Donnell, and the first pretrial date will be January 20th, 2022. Is that understood, Mr. Schreiber?
Yes, Judge.
The defendant also has a warrant out in the city of Strongsville as well for your purposes.
Thanks,
And
Your Honor.
let's move, go ahead.
State also requests a DNA sample be collected.
The DNA sample will be collected on this matter. So DNA will be required at this point in time at your processing, Ms. McLeod. Okay.
Very good, Judge, thank you.
Do you want to do the second?
Yeah, I'll do the second case now. Case number 666571B. In this case matter, the bond will be set at $500,000, cash surety property. There'll be no contact with the victim, and the DNA sample will in fact be obtained as well.
Do you want GPS on that?
GPS, same conditions apply, 24-hour lockdown, standard home detention. Thank you. All right, thank you, Mr. Filiatro.
Thank you, Judge.
Thanks, Judge.
Thank you, Mr. Schroeder.
Judge, did you want to take a couple of minutes for them to clear out here?
All right, now that this case is over with, the court will proceed with the other cases. I'll allow everyone the opportunity to leave here. Thank you.
Thank you, Your Honor. Kevin, which one's you?
I'm on the side. I gotta,
Who's of these? Is that his?
no.
That's me. That's 8.
I got you, Kev. Kev. Thank you all.